I will call the next case. It's Lakeshore Group versus the State of Michigan and Department of Environmental Quality. It's a 15-minute mini oral argument on the application. That means, Mr. Ordway, you may try to reserve some time for rebuttal, and if you are ready, you may proceed.
Good morning, Your Honor, Chief Justice, Justices, may it please the Court. I'm Dustin Ordway on behalf of Appellants Lakeshore Group and its members. I may have missed what you just said, Chief Justice. If I can reserve time, should any remain of 5 minutes for rebuttal, I would do that. But my primary purpose this morning is simply to answer your questions. There are a couple of points subject to your questions, which I invite you to ask at any time, that I would like to make. The first point is that we submit that ruling in our favor is simple and clearly correct. That is so under statutory interpretation doctrine for the simple reason that Section 1701, the first section of MEPA, the Michigan Environmental Protection Act, says any person can sue any other person to protect the environment. Person is defined in another part of the Natural Resources and Environmental Protection Act, Section 301, found at MCL 324.301, to include any governmental entity, which would include the department. Thus, there's no question, based on the plain language of the statute, that the department can be a defendant. Second, the statute says any such action can be intended to protect the environment, and a violation can be reviewed by the court, and directs the court then to exercise its independent judgment to evaluate whether or not there may be impairment to the environment or natural resources of the state. I would also direct the court's attention to Section 1705, the fifth section of MEPA, which specifically says that in an administrative action, two things must happen. First, the administrative agency must consider and determine whether its actions will impair the environment. And second, the administrative agency must not authorize or allow conduct by the permittee if that will or may impair the environment. Clearly, that provision applies to the work of the department. I use the department generally for the agency, the defendant, formerly DEQ, now EGLE, the Department of Environment, Great Lakes, and Energy. We've tried to make the point in our brief very simple and clear that all of its work is intended, it is charged with affecting the environment. And in addition, when it makes a decision and allows a permit, going to this court's first question to us on this application, it is making a decision whether to allow something that can or will affect the environment. That's its entire function. So for the department to argue that it's not subject to MEPA, except in the context of an administrative review, is puzzling to say the least.
Counsel, I just wanted to, what's the status right now of the underlying administrative proceeding involving the development?
In a prior application, this court remanded the case. It has not proceeded. The administrative tribunal has not approached us to say, when do you want your hearing? And in marshaling our resources with this additional application pending, we have not pursued completing that before we could be heard on this application. So it is still pending. The permits are still not final.
So as a practical matter, if we were to agree with your position today, what would happen next with the Court of Claims, and how would it work procedurally?
My assumption, Your Honor, is that this case would, against the department, would be remanded to the Court of Claims. We would hope that, as has often been common in past practice, the department would acquiesce to one judge serving as the circuit court judge and in the capacity of a Court of Claims judge. But that might not be the case. We might have then two MEPA actions pending, because we do still have a MEPA action against the developer, the permittee, in Ingham County Circuit Court. And so we might have two circuit court actions pending. We would hope the two judges would coordinate with one another, because we would be, in effect, depending on the same evidence, the same witnesses in both. And we would have to consider early on in either or both of those proceedings whether we would ask the court then to refer back, as MEPA allows, to the administrative proceeding to have it continue, complete the administrative review with the court retaining jurisdiction, and then come back to the court.
Thank
So
you.
it's all one action. I'm sorry.
Oh, I was going to just, can you also help me with what's the status of the permits? The department says the permits have since expired, and does that make this question moot? And what's the status of the development? What's happening?
The development proceeded. It was never our intention to stop all development. It was never the purpose of my clients to say the dunes must remain completely pristine. There is Court of Appeals precedent we've cited in our brief that says that when permits are in a review process, the other arm in which this court remanded the case back down for administrative review has still not been completed. Until that process is completed, the permits are not final. So while on the one hand, the department argues that the permits were issued years ago, the 5 years is gone, the work's been done, this is moot. The fact is, legally, those permits were never finalized. The developer proceeded at his own risk. Probably not an unwise thing because, as I said, it's not our intention to say tear your house down, the 20-odd houses that are in the development and so on, but rather to focus attention in the administrative proceeding and in court on more than simply what the developer said, the permit application process the developer sought to do, but more on the process of how the department reviewed it. Just to give a couple of examples, Part 353, the Sand Dunes Protection and Management Act, requires the department to get complete information from the applicant. Did they do so? The department doesn't generate its own information to make a decision whether the environment will be impaired. They depend on the applicant. The legislature requires the department under 353 to balance the rights of the private property owner against the public interest in preserving certain qualities of the dunes. And the legislation requires the department to rely on the most comprehensive scientific information available. We submit, and our complaint has outlined some examples, that the department didn't do that, and that's the primary focus when we return, if we return. And would there be an opportunity, should a court say this permit should never have been issued, to argue that the developer must tear down the home? That is not our intention. That is not where this is going.
What is your intention? If it's not your, I mean, I don't, what did you want if you didn't want the development to proceed? It sounds like the homes are already built.
I'm sorry,
The homes are already built, is that correct?
I can't tell you for sure that every lot has been built on, but for the most part, yes. It was never our intention to stop all of that, but to explore and hopefully reach reasonable limitations. What can be done with fair respect to private property ownership that doesn't improperly impair the dunes? I can't tell you right now where that line should be drawn, but it's something that the department and the courts both would have to rule on. And
Counsel,
if there were departmental...
If you were to prevail, I apologize, I didn't mean to interrupt. Why don't you finish that thought and I'll ask that question.
No, I was just going to say that if the department's processes, its review were not proper, and we could get further clarity about how such permit applications should be reviewed, that would be, going back to your question, Chief Justice, a primary goal of this action. Because the Part 353, the Sand Dunes Protection and Management Act, does not have promulgated regulations. There are many terms in there that need to be developed further, and greater clarity is needed. Michigan has a large area of wonderful sand dunes. Everyone recognizes a great natural resource. We have a national park along the lake. Only a third of those dunes were put into what's called critical dunes, protected dunes. And the legislature said in those protected dunes, you can't do much of anything in the way of putting in a fence, a deck, an addition, a home, without getting a permit. This case is about attempting to advance how that process works so that people can get permits they should be allowed to have, but the department is fairly protecting that natural resource.
Is that your overall goal in terms of if you were to prevail here today, how would this impact other developments across the state?
I think it would simply, it would be subject obviously to what happens on remand and what the courts say, but the primary
But if you could write the opinion, what would you like the opinion to say as it pertains to future development across the state?
I would like it to say that the Preserve the Dunes decision is good law, that is consistent with the body of MIPA jurisprudence, that the dunes can be developed to the extent that there's a reasonable interest in using one's private property rights, but that it has to be managed by the department in balancing that against the public interest in what the legislature referred to as the diversity, the quality, and the functions of the dunes. And that when that's taking place, there's not only a right for administrative review, but that there's a right under MIPA for judicial review independently of the administrative review. As this court said more than once in the Preserve the Dunes decision, there's a right for review of department action. I'm sorry.
Oh, no problem. I guess my question is, we have to balance, right? And I totally understand your position, but we always have to balance as a court. Will that create, do you feel that will create a certain level of hardship upon developers?
I don't think.
Or do you think that's just, or do you think that it wouldn't create, I mean, I guess my question is, how do I balance that? The balance of would that create a problem for development? Or, I mean, how do I balance the need for, basically people doing development versus the implementation that you would kind of put forth? How would we balance it as a court?
I think the balancing in the first instance would be done by the department, which literally Part 353 requires, and then would be reviewed by the courts as well. And if there's an issue that the balance has not been properly resolved, the court can address that. It would not harm developers, just as we do not intend to try to block what happened here. We could have filed a MIPA action several years ago before we were up on appeal and sought to enjoin all action. It was not our intention. We didn't do that. So,
Counsel, can you?
What?
Oh, I'm sorry. Can you explain for me, or provide the argument that, say we agree with you that under Preserve the Dunes, a reasonable interpretation of that opinion is, they're not saying every permitting decision precludes, that a MIPA action. And so you don't need to overturn Preserve the Dunes, but here the lower court sort of, for lack of a better analogy, used a hatchet instead of using a scalpel to figure out what claims, what permitting decisions actually fall under the terms of MIPA. But I think there's also an argument that the Sand Dune Protection and Management Act has a provision that specifically governs challenges to permitting decisions, and it's more narrow and specific than MIPA. Why would the legislature put that provision in the Sand Dunes Act and still say, well, you have this broader remedy under MIPA?
Yeah, I believe you're referring, Justice Cavanagh, to 35305, which is the right for appellate review at the end of a contested case decision.
Right.
And every, or just about every, environmental permitting part of NREPA has such a provision, because that's how the legislature has included recognition of the right for administrative review and then circuit court appellate review of the administrative process. But another part of NREPA, it's all the same statute. It's one act, and as of 1995, the Sand Dunes Act is 353, Part 353. MIPA is Part 17. The legislature put them all in together in one act, and MIPA provides for independent action in circuit court to review decisions of departments and to require compliance in order to avoid impairment of our natural resources.
So one is not a substitute for the other.
Right, one's not a substitute for the other. They're very different actions. One is not collateral. I believe we addressed in the brief that we submit that in Preserve the Dunes, when the court referred to improper collateral attack using MIPA, it was because the focus of the Preserve the Dunes decision was on a very narrow status decision that Section 63702 addressed eligibility. It was not an environmental matter. It was a predicate before the environmental questions were even addressed. And the court said, this is a collateral attack to use an environmental statute, MIPA, to challenge what's really not even relevant. It's unrelated, the court repeatedly said, to environmental protection. So are there two paths? Yes. Is the department correct that somehow that makes it wrong for the legislature to have authorized litigation using MIPA? We submit no. And we submit the statutory language is clear, and the right to pursue it is obvious. And the jurisprudence, going back to Vanderklut, Ray, Nemeth, the other cases that have been cited by this court, make it very clear that the legislature not only authorized such action, but wanted courts in those actions not to defer to the department, but was required by the legislature to exercise its independent judgment. And then that's an important part of protecting the environment of the state.
Mr. Ordway, I'm wondering how we square the WMEAC, West Michigan Environmental Action Council decision, which of course allowed the nonprofit to move forward with an action challenging a permit using the Michigan EPA, with Preserve the Dunes. I mean, it sounds like you're discussing a more conservative approach to sort of square those together, but I was just wondering what your best argument is for getting that done.
If I understand your question, Your Honor, let me try to address how we're reading Preserve the Dunes, because we don't see it as in conflict with Ray or WMEAC or the other decisions. The department suggests that Preserve the Dunes stands for the proposition based on one sentence that administrative action standing on itself alone does not affect the environment, therefore means that you can never use MIPA, you can never pursue action against the department as to any administrative action. But it was referring really, as the sentence before it made very plain, only to that other eligibility issue, a status issue, not an environmental issue. So that what the court did in Preserve the Dunes is not at all inconsistent with, and it never discussed the possibility, much less a decision, to overturn Ray or Nemeth or any of the other decisions. Now, I will acknowledge in the dissent to Preserve the Dunes, the position was taken that, look, if a party's not even eligible for a permit, then they can't get a mining permit. They can't go and destroy the dune by taking all the sand. Therefore, it's an environmental issue. Well, the majority decided that that was wrong. The majority decided that it's a status decision, it's not an environmental decision, and we're not trying to change that. Could one argue, as some of the amicus have argued, that if the court sees Preserve the Dunes as conflicting with prior MIPA jurisprudence, it should overturn it? They've made that point. We're not making that argument because we don't think it's necessary. We don't think it's called for. We understand the very narrow exception that the majority in Preserve the Dunes crafted, and there's no problem proceeding, there's no problem with MIPA cases being filed, except for the fact that the department has one at a time convinced the lower courts that that sentence taken out of context means, hey, they can't sue us. There's no such thing as a MIPA action against the state anymore. That's why it's so important for this court on this case to, we respectfully request, rule in our favor.
And Justice Bernstein asked you some questions about the need for a balancing act between, development and environmental protections. Am I correct to say that that balancing would sort of happen at this step? Is that an accurate statement?
At this step.
If we were to agree with your position and this had to go back, isn't that, it's allowing someone to just get in the door to make the claim, isn't that correct?
Yes, if I'm following your question, the balancing process would take place, and ruling in our favor and sending this case back would not say there is no balancing, there can never be any effect on the sand dunes. The question is judging what is unlawful impairment. And the outcome of that process is not to say to a property owner or developer, you cannot put in a home, or it's got to be on stilts, or any other specific thing. The balancing would be allowed to happen.
Thank you.
We've used up all of your time and then some. Thank you, Mr.
Thank you,
Ordway.
Your Honor.
Yeah. Good morning, Your Honors. Dan Bock, Assistant Attorney General on behalf of the DEQ. The court today should deny leave in this matter or alternatively affirm the decisions of the lower courts because a DEQ permitting decision must be challenged through the administrative appeal process and not through a collateral attack in an original action in the Court of Claims. The facts of this case starkly illustrate why. As the court's aware, Lakeshore already has an administrative contested case through which it can obtain judicial review of all of the issues set forth in its complaint here. It also has an ongoing MEPA action in the circuit court against the developer through which it could have obtained preliminary and permanent injunctive relief to prevent any harm to natural resources. Simply put, Lakeshore does not need a third bite at the apple, an additional duplicative lawsuit in this situation. As a practical matter, this case is moot. The permits at issue all expired over a year ago. As Mr. Ordway acknowledged just now, in the circuit court MEPA action, Lakeshore never sought a preliminary injunction, which was expressly available. I spoke to the permittee's counsel just a few days ago to check the status. The permittee is dissolved. It was a limited partnership, dissolved last year. The property's all been conveyed to other parties and houses have been built. At bottom, this case is not about environmental protection, it's about process. The issue before the court here is how does one obtain judicial review of a DEQ permitting decision? For the most part, I'm going to rely on my brief today, but in deciding this case, I'm going to ask the court to consider 2 points that illustrate the significant impact that reversal of the Court of Appeals would have here. First, the relief that Lakeshore seeks would upend the well-established administrative review process through which courts review final agency decisions, that final decision which is reached through the contested case process. And it would empower the Court of Claims to routinely subject non-final agency decisions to judicial review. And secondly, the relief that Lakeshore seeks as a practical matter is simply not available, and if granted by the court, it would create chaotic results. A party could file 3 separate lawsuits, contested case against DEQ, MEPA action against DEQ in the Court of Claims, MEPA action against the permittee in the circuit court, all seeking identical relief. It's not difficult to see the problems posed by duplicative litigation, inconsistent results, and there are significant constitutional problems with that approach, which I touched on in my brief, but I hope to flesh out today a little bit more.
Counsel, what do you make of your opposing counsel's argument that says that may be the case, but the legislature knew exactly what it was doing by putting all of these avenues available under the one act, under NREPA, and there are differences, would you acknowledge, between, I mean, maybe they're not significant, maybe they don't warrant really sort of considering them that different, but there are differences of who can sue and what kind of relief you can get, and so there are multiple paths that the legislature set out. How do you address that?
Certainly, Your Honor. So first of all, in terms of all these different statutes being combined in the NREPA, right? Prior to 1995, Michigan had just a collection of freestanding environmental statutes that bore no direct relation to each other. In the mid-90s, through Public Act 451 of 1994, as well as an additional Public Act in 95, the legislature combined them all into one act, the NREPA, and each previously freestanding statute is now a separate part of NREPA. And that's led to some tension between different parts of NREPA. However, with regard to what the legislature intended, as we set forth in our brief, when MEPA was enacted, there were no environmental permitting statutes in Michigan. MEPA is a 1970 statute. It predates this framework. And so we have this tension where we've sort of sandwiched together in one act these statutes that were not written to be harmonious with one another. But the issue here, as this court held and preserved the dunes, MEPA provides for declaratory and injunctive relief to prevent conduct that would pollute, impair, or destroy natural resources or the public trust. The issuance of a permit standing alone does not do that. There is an intervening event that must occur, which is the party must actually perform the permitted work.
What about the language that says that it does pollute or is likely to impair the environment? Why isn't a permitting decision likely to impair the environment?
Well, and Your Honor, we raised this in our supplemental brief where in Lakeshore's supplemental it said, certainly the issuance of a permit makes it more likely that the permittee will pollute, impair, or destroy natural resources. But MEPA doesn't say that injunctive relief lies against somebody who does anything that makes it more likely that someone else's conduct will pollute, impair, or destroy natural resources. An action lies to prevent conduct that itself will or is likely to pollute, impair, or destroy natural resources. And that was this court's holding in Preserve the Dunes, was that an administrative decision does not pollute, impair, or destroy. I want to briefly address Lakeshore's efforts to distinguish preserve the dunes are simply not supported by the language of preserve the dunes or any of the case law, any of its progeny. The very next sentence in preserve the dunes, contrary to what Lakeshore argues, DEQ is not focusing myopically on this one sentence. The very next sentence of that case says, review of administrative permitting decisions is obtained through the Administrative Procedures Act, Revised Judicature Act, or an appeal mechanism contained within the statute itself. And in section G of the Preserve the Dunes, which was the response to the dissent, the majority said specifically that they were referring to permits for conduct that affect natural resources. Additionally, every court to consider Preserve the Dunes since then has interpreted that case as DEQ does here, including this court. I think the Anglers of the Au Sable cases are extremely instructive. In Anglers 2, the 2010 case where this court overturned Preserve the Dunes, this court held that the Court of Appeals had interpreted Preserve the Dunes properly. If this court meant something different than what everyone understands Preserve the Dunes to mean, it could have said so, but it did not do that. It acknowledged that was what Preserve the Dunes says. Specifically said, until Preserve the Dunes, we'd never held that permitting decisions were insulated from MEPA, and they reversed Preserve the Dunes. That reversal was subsequently vacated. Now, I would just point out quickly, in their supplemental brief, Lakeshore argues that this court was simply wrong. It didn't understand Preserve the Dunes. And we pointed this out in our supplemental, but I'll reiterate again today. 5 of the 7 justices who wrote Anglers 2 also wrote Preserve the Dunes. And so the argument that those 5 justices did not understand their own prior decision is simply not a tenable argument. Now, I think it's important to consider the impact that the relief that Lakeshore seeks would have on the administrative review process. Michigan's Constitution provides for judicial review of final agency decisions. That's Article 6, Section 28. Michigan law is clear that the final decision is the decision that is reached after a contested case. If this court was to empower the Court of Claims to overturn permitting decisions without allowing the agency to distill its decision through the contested case process, which I know I don't need to tell the court the policy reasons behind that. We've cited those extensively in our brief. But the entire reason is to have the contested case process where a specialist subject matter expert finds facts, serves judicial economy, and it affords the executive branch the opportunity to reach its final decision before that decision is reviewed. What Lakeshore seeks in this case would turn that process on its head. And it would be, frankly, an affront to the separation of powers. It would change the relationship between the 2 branches if the judicial branch was to routinely commandeer the non-final decision-making process of the agencies by overturning non-final decisions. Now, additionally, we've cited authority in our supplemental, the Nummer case, the Champions Auto Ferry case, where both this court and the Court of Appeals have held that the contested case process has preclusive effect. A party cannot litigate a contested case, decide it doesn't like the result, and then file a MEPA action, or any other action, any collateral attack in the circuit courts or the Court of Claims. Similarly, in Champions Auto Ferry, the Court of Appeals held that the failure to bring a contested case within the designated time frame, which for these kind of permits is 60 days, also has preclusive effect and prevents subsequent collateral attacks in the courts. Lakeshore seeks to open the door and turn that system on its head, frankly speaking. Additionally, I'd ask the court to consider, and the court is clearly already considering this going forward, how this is going to work. Through their papers, Lakeshore and some of the amici sort of took DEQ to task for removing these claims to the Court of Claims and saying, and I hope it's not lost on the court, Lakeshore's argument essentially is they only wanted 2 identical lawsuits in 2 separate forms against the DEQ. We added a third by removing to the proper court that has exclusive original jurisdiction. We had to do that. This presents a problem because when a permit has already been issued, there are 2 things that come into play. Number 1, the permittee has a property right in that permit. They have due process rights. That permit cannot be taken away from them without an opportunity to defend themselves and defend their permit. Under the Administrative Procedures Act, that's what's referred to as a Rogers hearing. I'm sure the court's familiar with that process. It involves the agency implementing administrative proceedings against the permittee to revoke the permit. Now, what Lakeshore is contemplating here is an action in the Court of Claims under MIPA against the DEQ where the permittee cannot be a party, which would take away their permit. That raises serious implications with regard to the permittee's due process rights, and it also raises serious questions about what the Court of Claims would order. Is it going to order DEQ to revoke a permit? DEQ would have to initiate administrative proceedings, the Rogers hearing, and have a predetermined outcome to do that. It simply is not tenable. The better reading of the interplay between MIPA and the permitting statutes that came afterward, and this is consistent with the text of MIPA, which nowhere in its text says that it is a permit appeal statute. MIPA is designed, as the court's well aware, to provide a cause of action to prevent pollution, impairment, or destruction of natural resources. MIPA does apply in the permitting process, absolutely. And when Lakeshore brings its contested case against the department, it is absolutely free to argue that the department's permitting decisions ran afoul of MIPA because the department issued permits without adequately considering whether the conduct being authorized would pollute, impair, or destroy, or whether there were feasible and prudent alternatives, which is what MIPA said. And I pointed this out in our supplemental, but since every part of NAREPA as it exists now was drafted after MIPA already existed, virtually every part already includes consideration of protection of natural resources and whether there are feasible and prudent alternatives that are available. I'm aware of two parts that don't. I've referenced them in our supplemental. One of them happens to be Part 353. It required DEQ to consider feasible and prudent alternatives up until the 2012 amendments, which took that part out. But since then, and I've cited two current cases where we're getting sued for considering MIPA directly in a Part 353 permit review. Part 353 says it has to be decided in accordance with other applicable statutes. DEQ's taken the position that MIPA is just such a statute, and we've denied 353 permit applications for violating MIPA. There we apply MIPA directly because 353 has no analog to MIPA like the other parts do, if that makes sense. The other part is Part 619, which is drilling in the Pigeon River Country State Forest. I cited the Schmoody Oil Company, one of my cases actually where Court of Appeals upheld DEQ's decision to deny oil drilling permits in the Pigeon River Country State Forest based on MIPA. Now, the language of that opinion is not 100% clear. It references MIPA.
Counsel, I just have a quick question. Is kind of the gist of the argument that if they were able to proceed, that it would cause chaos in the system? I'm just trying to understand kind of what's the harm?
Certainly, Your Honor. The harm is, there are several aspects of harm. Number one, as Mr. Ordway acknowledged today, there would be duplicative litigation.
Okay.
We'd have 3 separate lawsuits, at least 2, possibly 3, in different fora considering the exact same issues. In this case, it's at the same time. It doesn't have to be at the same time. A contested case under the administrative rules has to be brought within 60 days. A MIPA action can be brought within 6 years of the permitting decision. The permits expire after 5. And so we would have exactly what we have here. Theoretically, Lakeshore could have brought its contested case, litigated it through to completion, decided it didn't like the result. It still has a couple years on its MIPA action, MIPA statute of limitations, and then bring a MIPA action. Or it could bring them simultaneously, as it did here. Additionally, there's more harm. As I said earlier, there's harm to the executive branch and to the agency itself, which would be denied the opportunity to reach its final decision, which is a clear requirement in Michigan law, before that decision is reviewed by the courts. The court rules and the Administrative Procedures Act provide that the non-final decisions of agencies are not reviewable by the courts, except in the rare situation where a court finds that litigating the contested case through to completion would prejudice the petitioner. And so I didn't phrase that exactly right, but that's the gist of those provisions. And so this would be directly contrary to that. It'd be directly contrary to the administrative law framework that, as we've said in our supplemental brief, is endorsed by this court, the U.S. Supreme Court, and I said virtually every state. I'm quite certain it's every state, but I have to confess I didn't do a full survey. But I believe every state follows that same basic framework.
Doesn't the possibility of, collateral estoppel or res judicata issues guard against that? I mean, people can litigate, you know, a 1983 plaintiff can bring an action in federal court and in state court and runs the risk that they're going to be bound by the first to judgment, right? I mean, that's like all the wheels don't fall off if we litigate in two different actions in two different courts. But there is a, you know, that's a risk analysis to be calculated by the plaintiff in when and where to bring their suit when both avenues are permissible.
But there are two, I understand, Your Honor, but there are two problems with that. First, as we've said earlier, we still have the harm to the executive branch of the courts reviewing the non-final decisions, and we still have a conflict between, Part 353 provides a review mechanism. It doesn't say that's one option. It doesn't say you can do this and do something else. And of course, we have the expressio unius principle when the legislature provides a permit review mechanism that's presumed to be exclusive. That's the 60-day statute of limitations, and that affords the agency the chance to reach its final decision before it's subject to judicial review. And so to find, as Lakeshore requests, it would require relegating that administrative review process to merely one option. It would also require reading into MIPA a provision that doesn't exist. It would require reading into MIPA something that says, this is an administrative appeal statute that provides judicial review of non-final agency decisions that make it more likely that another third party might engage in conduct that would pollute, impair, or destroy natural resources. This is simply not what MIPA was intended to do, and that's exactly what this court held in Preserve the Dunes, and that's why the Court of Claims and the Court of Appeals got it right in this case. As we've said, Lakeshore can obtain the full suite of relief that it seeks without upending the administrative review process, without having litigation in the Court of Claims where the permittee might lose their permit where they can't even be a party, without having the Court of Claims ordering an agency to initiate administrative proceedings to revoke a permit when those proceedings necessarily involve the agency bringing an action against the permittee to revoke, the permittee having an opportunity to defend that revocation. This would essentially do violence to a number of well-established principles of administrative law, constitutional law, and for what purpose? For the purpose of allowing 3 simultaneous lawsuits instead of 2, in which the full suite of relief is available in the existing 2. I would also point out to the court, MIPA, I believe it's 1706, provides that it is supplementary to any existing administrative review procedures. It doesn't say it is in addition to those procedures, or it is a separately equally viable option. It says supplementary, which means it exists to fill in the gaps. And we've traced this out particularly in our supplemental brief. But the way that works, there's a problem where administrative law judges do not have equitable powers. Actually, in this case, Lakeshore asked the ALJ repeatedly for injunctive relief in the early goings of the contested case, and the ALJ ruled repeatedly, I don't have the authority to do that. So if Lakeshore had wanted the permittee to not do the construction while the case goes forward, you file your contested case against DEQ, where, by the way, that's an action against DEQ. It's not against the permittee. They can intervene. They usually do. Some rare occasions they don't. But you file your contested case to challenge the permit. You file a MIPA action against the permittee to get the preliminary injunction that is expressly contemplated in MIPA. Preliminary injunction while the administrative proceedings go forward, and then the circuit court retains jurisdiction for the appeal from those administrative proceedings, which is expressly allowed under the Court of Claims Act, right? There's an exception in 600.6419 for administrative appeals. And so we have a very clear system set up here, and the court was correct in Preserve the Dunes when it adhered to that system, and the Court of Claims and the Court of Appeals were correct here when they based their decision on those prior holdings. And so I believe that concludes everything I have, unless the court has any further questions.
Counsel, I actually do have a question. You said that the cause of action that's before us today is not what MIPA was for. Can you tell me what MIPA is for?
Certainly. MIPA was for the exact action they brought against the developer to prevent the actual conduct that might pollute, impair, or destroy natural resources. And additionally, I should briefly point out, Lakeshore and the amici have made much of the fact that, yes, there have been a lot of MIPA cases against the government over the years, 100%. That has happened. And nowhere has DEQ argued that it is immune from MIPA, or that, Mr. Ordway said this morning that DEQ is arguing that there's no such thing as a MIPA action against the state. Not true. In every case that Mr. Ordway referenced today that involved the state government or local government, Ray, Vanderkloot, Ide versus State, Oscoda chapter of PBB Action Committee, the government was the one performing some action. Those were not challenges to permitting decisions. Those were challenges to government projects. Vanderkloot, the Department of Transportation, was building a highway. Ray, the Mason County Drain Commissioner, was digging a channel. Oscoda chapter of PBB Action Committee, DNR, for some reason was burying animals in the ground, and they were emitting toxic chemicals, et cetera. There have also been cases, we've run through this in our supplemental brief. A number of the other cases were distinguishable for other reasons. Really, the only case that comes close to supporting Lakeshore's position is the WMIAC case. And I would point out a couple of things. First of all, in that case, this court specifically noted that it was unclear whether that action actually pled that the issuance of the permits violated MIPA, but noted that no one was disputing it and that issue was not before the court, so the court assumed it could do so because, I shouldn't say assumed, but the court held it could do so because no one was opposing it. Preserve the Dunes was the first case where anyone ever actually said, look, there's a separate administrative appeal process that must be followed, and MIPA does not replace it. And so MIPA absolutely provides for actions against developers. It provides for action, that includes the government, when the government, DNR is building a boat launch or something, but it does not provide for an appeal of an agency permitting decision separate and in addition to the actual more recently enacted, more specific permit appeal statute. And again, we have the problem with the statute of limitations where, the mootness in this case will repeat itself. On that note, I will stop repeating myself, and I would just ask the court, unless there are any further questions, please, to make a bad pun, preserve the administrative appeal process and affirm the decisions of the lower courts or deny leave in this matter because the Court of Claims and the Court of Appeals got this one right.
Thank you. Thank you both. The case will be submitted.
Thank you.